Hello everyone and welcome back to my channel, Now I Know My Rights, a channel and a platform dedicated to teaching you your rights. In today's presentation, we learn how to defend a lawsuit in small claims court. Getting served with legal papers is demanding and tough, especially if you think you've done nothing wrong and that plaintiff is being overly aggressive and totally unreasonable in filing the claim. Regardless, you have to defend it. In small claims court, you are defending yourself. You are representing yourself. So it's very important that you don't transfer your anger and frustration to the court. Treating the plaintiff with respect and dignity will go a long way. Also, you have to do your homework. Gather as much evidence as possible to bring credibility to your side of the story. There is a saying that in small claims court, there are three sides to every story: the plaintiffs, the defendants, and the judges. The reason is the judges take an active role in small claims court. They question everyone to determine liability and damages. Your job is to convince the judge of your side of the story. Without any further ado, let's start today's presentation.
The top 10 tips on how to defend a case in small claims court. The following presentation is an overview of how to defend a case in small claims court. 1. Summons and complaint. If you are served with a lawsuit, don't ignore it. Even if the claim is frivolous, and even if you believe the complaint is filed for revenge and retaliation, you have to respond to it in a logical, rational, and most importantly, legal manner. The claim will not magically disappear on its own. Instead of getting emotional, read through each page and find out who is suing you, what is the amount claimed, why are you being sued, how much time you have to respond, and when is your court date. Note all of these on a chart so that you are clear as to the basics of the lawsuit. The next step is to check for any procedural defects that could potentially delay or dismiss the case. Once you've checked all the procedural grounds, you have to formulate and organize your substantive defense. 2. Procedural issues, proper service, and proper venue. No lawsuit is complete without proper service. If you are served personally, which means the summons and the complaint was handed to you by a proper server, the service is complete. If the server approached you and you refused to take the papers, or if you were hostile or attempted to run away, the process server can put the papers down and leave. That would still be valid service. Service by certified mail is allowed in many jurisdictions, and it is often done by the clerk of the court. Substituted service is also allowed in many jurisdictions when reasonable efforts to serve the defendant has failed. If you were served late, without sufficient time to respond, if your papers were left with a neighbor, or if there are other grounds that you believe service was improper, contact the clerk of the court to explain the problem with service. Plaintiff needs to comply with venue and jurisdictional limits when filing the claim. The term venue refers to the proper place in which to file a lawsuit. Correct venue is typically where the defendant resides. In a breach of contract case, it is where the contract was formed. For personal injury cases, it is where the incident took place. If you think the case is filed at the wrong venue, contact the clerk of the court. Never risk an entry of a judgment by default by not showing up at the hearing because you think the service or venue is improper. 3. The statute of limitations. Time is a critical issue in filing of cases. Plaintiff must file the lawsuit within a particular period called the statute of limitations. The time frame is usually 1 to 6 years, depending on the cause of action. If the plaintiff filed too late, the action is time barred. For example, in California, statute of limitations for breach of an oral contract is 2 years. For breach of a written contract, it is 4 years. For personal injury claims based on negligence, it is 2 years. Talk to a small claims court advisor at the self-help and find out the applicable statute of limitations to the cause of action at issue. 4. Motion to dismiss. With all the procedural defects that we just covered, including the statute of limitations, you, as the defendant, can file a motion to dismiss and ask the judge to dismiss the case. Your motion might be set for a hearing, or the judge can also issue a written decision without hearing. 5. Negotiate a settlement. If you think the plaintiff has a strong legal position and is asking for a reasonable amount, you should reach out and settle before the hearing. At the very least, you will be avoiding a hearing that you know will not result in your favor. 6. What to do when plaintiff is demanding too much money? If you know that you are liable, but the plaintiff wants too much money, gather as much evidence as you can on the true value of what you owe. For example, if the plaintiff is demanding $10,000 for a minor fender bender to his 20-year-old car, take proof that the car's total value is $5,000. The only way to discount accurate claims is by evidence of its real worth. Take appraisals, estimates, pictures, expert opinion letters, official publication value guides, such as the Kelly Blue Book, so that you can establish at the hearing the true value of the claim. 7. What to do when you don't have a plausible defense? If you know that the plaintiff has a strong case, meaning the law is on his or her side, and you are liable, but you are unable to reach a settlement, your best chance of prevailing in court is to create holes in the plaintiff's case. It means you will bring up issues that would prevent the plaintiff from meeting the evidentiary standard of proof. To do this, look at the key points in the plaintiff's story See if any of them can be disputed. For example, if the dispute is about goods and services that you received, argue that they were substandard. If you show that by some evidence they were substandard, the judge would probably rule that you don't have to pay the full amount. 8. Preparation and presentation of your defense. Always read the law and educate yourself on the type of your case. For example, in a contract dispute, if there is no written contract, you have the upper hand. You can dispute the heart of the case and argue that an agreement was never reached. Even if there was partial performance, you can argue that there was no meeting of the minds. There would be lots of he said, she said when there is no written contract. Another example, you can argue that even if a valid contract existed in the first place, the plaintiff has completely violated its terms so that you were justified in considering it void. Gather all your evidence to establish your defense. The following items are all acceptable forms of evidence: written contracts, letters, leases, emails, receipts, recordings, canceled checks, money orders, warranties, estimates, and damaged objects. Witnesses go a long way. They can be someone with first-hand knowledge of the issues or a specialist that can provide expert testimony. For example, if you are a computer repair person sued by someone who claims you damaged their computer, if you get a written opinion from another shop that the current problem with the computer has nothing to do with what you fixed, it will help your case. Another example, if your tenant sues you over withholding the security deposit, focus on the exact point of the dispute by showing the before and after pictures of damages and an itemized report of how much you paid to each handyman or a cleaning crew to bring it back to its original condition. In court, keep in mind, your attitude goes a long way. Be composed, collected, and confident. At the hearing, plaintiff will have a few minutes to present his or her case and answer any questions the judge may have. Don't interrupt the plaintiff or the judge. Keep your calm. Be courteous. The judge will notice your mannerism. When it's your turn, give a brief overview of your case. Give the most important points first, and don't repeat facts which are not in dispute. The key to winning the case is to convince the judge of your version of the facts. 9. Filing of a defendant's claim. If you believe it is the plaintiff who is at fault and you want to sue the plaintiff, you should promptly file a claim of defendant in the same court for up to the small claims court maximum amount. Don't wait until after the plaintiff's case is resolved to bring your lawsuit. In many states, if you don't file a counterclaim, you will lose your right to bring your claim against the plaintiff. Always file and serve the papers as soon as possible. Both your claim and plaintiff's claim will be heard together. You should present your counterclaim as if you had filed the claim first. Cover the legal elements backed up by the facts and the evidence. 10. Judgment. Get a copy of the Notice of Entry of Judgment. As a defendant, you have 30 days to file a motion to vacate or appeal the judgment. If you prevail on your defendant's claim against the plaintiff, you have to wait 30 days before you try to enforce the judgment. Consult with the clerk at the county's collection department on how to pay or collect a judgment. Just as you should never ignore getting served with a summons and complaint, you should never ignore a judgment either.